think we need to get started. My name is James Orwa. I'm affiliated to Uzima, which is based in Aga Khan University in Nairobi. So for this session, I'll be the facilitator for the two presentations that we have this evening or this afternoon. So the first one is about DSI Africa Law by Aliki, and the other one is a recorded one by PubGem Africa by DeCoop. So how we proceed, we will first we start with the first one, but I'll encourage members to introduce themselves in the chat so that we know who we are as we start. And also, if I can see Carmen is in, if she wants to do it, if she wants to present, not playing the video, feel free to let me know so that I don't play the video. Otherwise, we'll have like 15 to 20 minutes for the presentation, then questions after each presentation. With that, I give chance to the first presenter, DSI Africa Law. Please share screen and continue.
Just going to unmute. Hello, everyone. I'm Aliki Edgecombe. I did upload a video, James. I don't know if you want to play it. Otherwise, I'm happy to do it live as well.
Please go ahead and do it live.
Okay, fantastic. Right, everyone. As I was saying, I'm Aliki Edgecombe from DSI Africa Law. And we exist in order to assist health researchers with all the legal implications of conducting health research on the African continent. We focus a lot of our time looking at data protection laws in particular, because that has been extremely tricky for health researchers to navigate, especially with them coming into force very recently, but I'll take you through that. And I'm part of a very dynamic team of researchers from across the continent and abroad, all specializing in different areas of health research, geospatial, artificial intelligence. So we really have a wonderful dynamic team. We're led by Professor Donald Thaldaar, who is our PI. We do research in 12 African countries. All of these have legislation available in the English language. So that's Botswana, Cameroon, the Gambia, Ghana, Kenya, Malawi, Nigeria, Rwanda, South Africa, Tanzania, Uganda, and Zimbabwe. And across these different jurisdictions, we look at a number of themes, including informed consent, because we know how important that is for health researchers who are gaining consent of research participants in order to conduct their health research projects. And ensuring that it actually does comply with the local laws is important, both for the use of that data in their research project and for future use as well. We also look at the rights of both personal rights as well as community rights in genomic data, which we know is of particular interest to those of you who are doing that research. We also look at geospatial data, especially with regards to public health surveillance, such as what happened with COVID-19. And we have a very keen focus on cross-border data sharing. This seems to be the biggest issue for the researchers that speak to us. And so we have put a lot of energy into creating
both of those DCR things to the second DEA meeting, which is
so we have put a lot of energy into creating guides about cross-border data sharing, and I'll tell you a little bit more about them as we continue. We also have a keen interest in artificial intelligence, knowing that this is making great waves in the health research context. Just actually attending the previous session, we heard how AI was being used. But looking at the legal implications is also important as well. And so we do research in that area. And of course, we are on the African continent. So looking at decolonization and the Africanization of laws that relate to the use of data and health research is an important part of what we do. And we do a lot of writing ensuring that, that African legal philosophy is integrated into everything that we do. Now, why is it important that we do this kind of research? Well, if you've been tracking data protection legislation over some time, you'll see that even within the 12 African jurisdictions that we've looked at, you can see how many of these countries have enacted these pieces of legislation, starting with Ghana back in 2012, and all the way up to the beginning of this year, Malawi putting in place their data protection laws. And these laws do impact health research. Health researchers are often dealing with very sensitive data of their research participants, which within the context of an act would be the data subjects. And as they're using that data, they're often sharing this data, sometimes even across borders. And all of that is going to be impacted by data protection laws, which they will have to comply with. And there are very heavy consequences for not complying with these pieces of legislation. If you actually just want to look at an Africa-wide sweep, you can see that all the green countries are countries that actually have data protection laws currently in place. We have some orange there, which means that there are bills in place. And in fact, this map is a little bit old because Malawi, as I've told you, has actually recently enacted a Data Protection Act. Only the countries in red currently don't have data protection laws in place, but we're expecting Africa to be green very soon and completely green very soon, which means that these laws are going to be impacting the research that you're doing, no matter where you're conducting this research on the continent. And I do understand that many are actually conducting across multiple jurisdictions, and that even creates further complications when you're trying to handle this kind of data, perhaps across borders and sharing it with other researchers. But it's not just actually at that stage of sharing that these questions become important, nor is it merely just in the case of consent, which is a lot of the times where you think about data protection. In fact, right at the beginning of the research project, right from the design phase through to consent, through to processing, sharing, and eventual publication, all of those stages of a research project are actually impacted by the data protection laws that are in place. Just for illustration purposes, because I've only been given 10 minutes to chat to you today, I'm just going to look at, for instance, how research design would be impacted by data protection laws. Now, when you're looking at research design, there are a number of questions that actually have to come to mind before you even get started. And a number of jurisdictions, especially where you're dealing with sensitive data, such as health data and genomic data, you may be required to actually conduct a data protection impact risk assessment. Like I said, this is jurisdiction dependent, but whether or not this is a requirement, this will be something that you'll need to consider as you kick off your research project. The first thing is that data protection acts actually enforce and encourage that there must be a particular purpose for data to be collected. So in other words, you can't have an undefined purpose of why you're collecting data. You need to think about it before you collect it. And so even at this designs phase, you're thinking about, well, why am I actually collecting data? And what data do I actually need to collect? Okay. So all of that needs to be included in your thinking around your research project, because some of that data might be particularly sensitive, which means that extra safeguards might be needed and might be needed to be put in place. Also, you're going to think about who can access the data. Who's the data controller? Who will be the processor? Sometimes this could be the same person. Sometimes they're different people. The data controller or the responsible party will generally be the PI and the institution, the research institution. You will also need to think about how you're going to collect that data and where you're going to store it and how. How long will you retain it? And especially when we're looking at health research, this becomes a tricky topic because most of the time you're wanting to keep this data for an extended period, if not forever. But in fact, data protection laws are forcing you to really think about how long you need to keep that data. And if you want to keep it for an extended time, really, does it need to be kept in an identifiable format? You might want to de-identify that or synonymize that. quite early on in the research if you're able to do that. And of course, like I've already mentioned, you want to really be thinking about how you're going to be minimizing risk, looking at things like anonymization and de-identification. So just looking at one example, one area, just a starting point, when you can see how much data protection laws are impacting your research project, it's incredibly vital that you understand these laws and make sure that you are complying with them from the outset. Because a failure to do that from the outset might mean that you're collecting data that you can't perhaps use legally in the future, which would be a great loss of your time and effort and energy and resources as well. We know that another important area is data sharing. I don't have enough time to go into each one of these. I've done quite a lot of presentations on data sharing, but in the Q&A, you're very welcome to ask me. And I also have one of my colleagues, Paul Eslar, who will be able to answer some of those questions. But just as a group, we've been able to actually give you a lot of information on how to do this legally in a legally compliant way and assist you with a few tools. So one of the tools that I'd love to highlight for you today is our data transfer template, which is available on our website, as well as other places online. I've put the QR code there for you to just quickly snap and then you can follow the link. But the DTA that was specifically designed for the South African context is completely adaptable. You can use it and change it according to your needs, and it's completely free of charge. It even comes with a little memo to help you work your way through it. So these are one of the really useful tools that is available for you who are doing research and will need something like a data transfer agreement because you are actually transferring this information. The other great place for you to visit is our website. It's at www.datalaw.africa. And on that, we have a number of really fantastic resources. You can actually just click on resources and you'll appear at a page like this, and you're able to search on it and actually find the resources that are really relevant to you. We've even got the year so that you can really see what is most up to date. And most of what papers that we are publishing, we put on this website, so they're really easy for you to find in one place. There are also a number of other really interesting articles that we've written. We've got some blog posts as well, so you're welcome to look at those, where we just in a far shorter piece look at some of the current issues around data protection, as well as we have the most up-to-date laws also available on our website. So our website is a great place for you to visit if you want to connect with the research that we're doing. For those of you who aren't great readers but enjoy listening to podcasts, we do actually have a podcast, a show as well. It's called Health Law, and if you are looking for it on any of the platforms that you enjoy using, then just look for Health Law for Professor Donwick Thildar, and it will pop up. And here we actually have really short little interview style explanations of many of the articles that we've done and research that we've done. So this is a great way to stay connected and understand what is happening within the data protection space, specifically with health research in mind. And if you are even part of the very modern generation that loves videos, well, we've even done a couple of videos for you. And you can see we've used images to be able to help communicate some more complex legal questions in a far more accessible way. Our goal at DSI Africa Law is always to make the law as accessible as possible for scientists so that they can confidently apply it to their particular context. So this is one of the tools and one of the ways that you can actually access this information. But the last thing I'd like to punt is what we've really been working towards as a group is our country reports. And these are guides that have summarized and give clear guidance in those 12 African countries on how to conduct health research in a legally compliant ways, looking at the Data Protection Acts, where they are in place. And like I've said, in most of those jurisdictions, they are currently in place. And looking at the major issues that would impact you as a health researcher, everything from consent to AI, but very specifically cross-border data sharing, which we know is such a big headache for many researchers and can become a sort of a major stress when you're trying to eventually share the data that you have. So we actually released these in draft format. They are available on our website, and they are being finalized for their release at the end of August this year. So you'll have these reports in these 12 African countries available very soon, and I'm sure an invite will go out via our network. So you're very welcome to come to the launch of that. And with that, with those country reports, we are also very excited to let you know about an AI powered chatbot that we have actually trained on the guides and on the legislation, so that there's a very easy interactive way that you can ask questions and even compare laws from different jurisdictions without having to flip through the 2 pieces of legislation or 2 guides. So for those of you who are doing cross-border data sharing and are trying to actually bring data in from multiple countries, this will be a great way and a great tool for you to just quickly look up some basic questions that would be applicable to a number of jurisdictions. So that's where I'm going to leave it. I'm going to, look forward to the Q&A. And I'd just like to finish off just by thanking the NIH and the National Institute for Mental Health, who actually provide us with a grant and sponsor and help us to actually do the research that we're doing. So we're very grateful to them for their continued support. Thank you very much.
Thank you, Aliki. I think I pronounced it well, Aliki. Okay, so I think we...
Perfect, James. Thank you.
Okay, I think we give you some comments and questions to the team for the good work they're doing on enlightening the researchers on ethics and the law. Questions for the team. You can either chat or just unmute and
I see in the chat that there was a question of whether I could share the slides. I'm very happy to send the slides on to anybody who would like the presentation. I've also sent them to the DSI Africa group, so maybe they can actually be distributed or put online as well. But yeah, anybody who would like the slides, you're very welcome to them.
you can also share your contacts and I can be contacted in the chat so that we can contact you later. Maybe you can shed some more light on how to go about geospatial data and how they can be, what you can do with that before either sharing it out or before we take it to the cloud.
Yes, if I have a bit of time to do that, I actually will go back to one of the slides that I think I just skipped over just for the sake of time. Yeah, when you're looking at cross-border data sharing, there are a number of different elements that you want to look at. The thing to understand is that each one of those jurisdictions that we looked at have their own data protection laws, and those laws are unique to those countries. So while there are similarities and themes that we can see cutting across all those jurisdictions, you have to really look at each specific country in order to gain clear guidance on what you are meant to do. So I'm giving you general principles that will apply, but please see these as general principles, and you will have to go to the legislation for more specific guidance. But the one thing when you're looking at cross-border data sharing, which a lot of the pieces of legislation actually provide for, is that there needs to be adequacy. In other words, there needs to be adequate safeguards in the country, the recipient country of that data. So if you are sharing your data, say, for instance, you're in South Africa and you're sharing data with Kenya, what we would look for if we looked at adequacy is to actually see that Kenya has adequate levels of protection that would equate to what we have within South Africa. So the goal is always that if there are rights and protections within one country, we want to see that if that data moves out of that country, are those rights and protections maintained in the country in which that data is being sent to? And so some countries like Nigeria have actually produced an adequacy list. So they have a list of countries which they say the laws and protections that are in place are adequate and are comparable to Nigeria. Not all countries have this list, unfortunately. So Nigeria seems to be ahead of everybody else. But that is one of the criteria that we're actually often looking for as a legal basis for sharing data. The basis that you're going to, and I really looked at looking at a data transfer agreement, so I'm not going to focus on that. The other part that's a little bit more technical is whether or not you can actually anonymize that data or de-identify that data. And even that, you really want to be careful when we're talking about anonymization and de-identification. In most of the jurisdictions that we look at, this specific data, if it is no longer identifiable, falls out of the data protection laws. So in other words, it's no longer governed by those data protection acts, and you can far more easily transfer that data. But you have to make sure that that data is in fact anonymized and de-identified. And the tests are often quite stringent. Within South Africa, that actually there is no means that can reasonably re-identify that person again. So in other words, you would not be able to re-identify that individual. And so the benchmark is high, and the debate has been around whether pseudonymized data can fall under this category. So obviously that's where you've just removed some names and other identifiers, but you actually keep the original data set. We've often said that that actually can never be seen as being anonymized because there is an original data set that can identify the data subject. But there's been a recent movement, and there's been some case law within the European Union that suggests otherwise, that if that pseudonymized data set, or if that identifying data set is actually kept separate and is not accessible to the recipient, and that recipient would have no legal means of actually gaining access to the identifying data set, then the pseudonymized data set that you shared could be seen as being anonymized or de-identified in the hands of that recipient. Now, it's a very technical issue that I'm raising now, but obviously it's quite helpful for those of you who are dealing with data where you do actually have an original data set. You're taking, say, historical data or data from hospital that would actually have original data set. Could they de-identify it or anonymize it to a point where it would now be de-identified in your hands? It would be on a case-by-case situation. You would be looking at that data. And unfortunately, we don't have any case law in Africa that gives us guidance. But because the European Union and the GDPR seems to be interpreted that way, we'll await to see whether that will stand. It may be that other African countries will follow suit. So that is one way to be able to transfer data a lot more easily across borders. And we're talking about in cases where you cannot get consent. Obviously, consent it becomes a legal means in order to transfer that data as well. I don't know if that helps in terms of answering those questions.
I don't see any question in the chat, but there's one comment from Paul saying that while the laws change according to countries, the basic mapping of the personal data you have, will you use it for, what you give it to, how you delete it, etc. will always be useful. Another one said all data protection lawyers will want this information, and it will really help to get to the answers as to what you need to do. Thank you so much.
So thank you, Paul. Yes, yeah, and thank you, Paul, for that. And that is what you want to track what you're doing, and you want to track why you've made the decisions that you've made when you're dealing with data. That's the most important thing actually to do. So thank you very much for the time.
Yes, I don't see any other comments or chat. We can go to the next presenter. Prof. De Kock, you let me know if you want me to play the video or you want to go live.
Hi, James. You can play the video, please.
Okay. Let me try again. Thank you, Likoka. Sorry, we have a challenge with the sound, but the recordings and the video and the clip will be shared. Anyway, if you have something that you may want to echo based on your presentation, please go ahead as we wait for questions or comments.
Thank you. Thanks for the opportunity. Yeah, I think I'd just like to acknowledge all the investigators and all the participants that are involved in the project. And I'd like to highlight that people can reach us at our website and also through our social networks. If you would like more information about the project or would like to contribute to any of the activities.
Thank you. Question or any comment for the team? We have more time, so we have more time for questions to seek clarifications. Even if you still have comment for the first presenter, please feel free. You can just raise your hand or unmute and speak out, or just type in the text. Anyone with any comment before I go back to the main group? I think you've said already about how people can reach. Do you allow for partnership for those who have interest in partnering with you in this work?
Yes, definitely. I think we, as with all the other DSA Africa projects, we definitely welcome in individuals or groups who would like to partner and to work on some of the objectives of the project.
Okay, and then the contact is your contact in the chat. Maybe you can type it once more. I know it's in the slides, but you can just type it once more in the chat. Thank you. That seems there's no any question in the chat, and I don't see anyone raising his or her own hand to give comment or question. I thank all of you for attending this session, and I hope we've learned and gained more experience on the ethics and data, both from PubGem and also from the Silo Africa, and how we can collaborate. Otherwise, thank you so much, and feel free to join other groups in the next 10 minutes before this one closes. So if you want to go back to the group, at bottom of your screen, there's a leave room. So click on leave room, and then you'll go back to any room you want, or you can go back to the main session. Otherwise, thank you so much and enjoy the rest of the session.